I'm Jim Turk, the director of the Center for Free Expression at Ryerson University, and I'm delighted that you're able to join us today. I'd like to begin by acknowledging that the land on which I am speaking to you is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and with the Williams Treaties signed with multiple Mississaugas and Chippewa bands. On behalf of the Center for Free Expression and the Creative School at Ryerson University, I want to welcome you to the fifth in this fall's series of conversations featuring prominent guests discussing important issues in the current political moment, in which democracy is under threat, public discourse on vital matters is fragmented into self-affirming ideological bubbles when not discouraged altogether, and censorship is increasingly seen as an ally rather than an impediment to social justice. I also would like to acknowledge and thank the co-sponsors for today's event, and they are the Edmonton Public Library, the Milton Public Library, the Toronto Public Library, and the Vancouver Public Library. Our conversation today features Charles Smith and Daniel Paré, and it's titled, "Watch What You Say, The Whole World is Becoming Your Workplace." Social media is breaking down the boundary between the workplace and our life outside of work. What you tweet or what you say on Facebook outside of work and with no relationship to your work is often available to your employer and is increasingly being used as a basis for discipline. How is this changing the relationship between employers and employees? What does it mean for employees and for their right to engage in public discourse, a right which underpins our whole democratic system? These are some of the issues that will be discussed today. And I'd like to introduce our two discussants. Charles Smith is an associate professor in the Department of Political Science at St. Thomas More College at the University of Saskatchewan. He is the author of several books and is co-editor of Canada's foremost labor studies journal, Labor Le Travail. His latest project, with his colleague Daniel Paré, examines the interconnection between workers' freedom of expression, social media, and workplace discipline in Canada. Welcome, Charles.
Thanks, Jim. Nice to be here.
We're glad you are. In conversation with Charles is Daniel Paré. Daniel is Associate Professor of Communications and Media Studies in the Department of Communications at the University of Ottawa and holds cross appointments with the university's Institute for Science, Society, and Policy and its School of Information Studies. Daniel is a former president of the Canadian Communications Association. Welcome, Daniel.
Hello, thank you.
For today's program, Daniel and Charles will be in conversation for about 45 to 55 minutes, at which point they will turn to the audience to bring you into the conversation. As you listen to their conversation, if you have questions that you'd like to ask them, issues you'd like to raise or have them comment upon, please enter them in the question and answer section. So if you look at the bottom of your screen, you'll see a Q&A button. Just click on that at any time that a question comes to mind or something you'd like them to comment upon comes to mind. Don't wait till we get to the audience engagement part of this. Just feel free to put up your question as it comes to you in the course of the event. And then, as I said, after about 45, 55 minutes, they'll turn to the audience and ask Ange Holmes, the coordinator of the center, to read the first question that come in, and then they'll go through each of your questions so that they can discuss the issues that are of concern to you that are raised by their conversation or in relation to it. So now it's time to hear from Charles and Daniel.
Thanks, Jim. It's nice to be here. I'm coming to you today from the interior of British Columbia, so I'm on the traditional homelands of the Lakota Dene. And it's one of the reasons I've got so much sunlight coming in because it's only 1 o'clock here, so it's neat to be doing this over multiple time zones. Daniel Paré and I, Daniel's can introduce himself in 1 second, have been engaging in this project for quite a few years now and have really been doing a deeper dive into understanding how the Canadian legal system, but particularly Canadian labor law, arbitrator decisions, labor boards, and court and judges in courts are rethinking the relationship between worker activity and employer discipline as it increasingly navigates outside the workplace, the physical workplace, vis-a-vis people engaging in social media activity. And we became interested in this as it seemed to be exploding in around 2014 and received some funding in about 2019 to explore this in more detail. I'm a political scientist with an interest in labor, so I'm very much interested in the legal regime. Dan's a communication scholar who's got a different theoretical approach, but I think together we really do combine this unique interaction based on our disciplines. So I'm going to be talking to Dan a little bit about some of this issue, but before I do that, would like to hand it over to Dan to introduce himself and to talk a little bit about the project.
Hello, everybody. I'm coming to you from the greater GTA today. So yeah, as Charles was saying, we've been working on this project now for about 3-4 years. As with so many other things, COVID has had an impact on progress with the project. To date, much of it has involved systematic content analyses of labor arbitration decisions and court decisions pertaining to social media postings from inside the workplace and from outside the workplace. And the issue that's been of concern to us has been sort of, this question of how the contested terrain between employee interests and employer interests are being balanced out in so much as, we refer to it as the emergence of a particular governance trajectory. And so there's two broad dimensions here that sort of encompass the sorts of things that we're looking at. The first, of course, is the tension between the importance of employees being able to communicate their voice about their workplace experiences and to be able to do this outside the workplace. That, of course, is counterbalanced by the interests of employers in trying to promote positive brand images and trying to protect their reputations. At another level of conflict, and one that we haven't explored too much yet, but our work is beginning to go in this direction, it pertains to how social media platforms are being used. And what I mean by that is the tension between the autonomy that workers can have in terms of using social media outside the workplace versus the desire of employers to try to regulate time, basically monitoring what employees are doing on company time, trying to ensure that they're not on email or Facebook or Twitter or TikTok or whatever while on company time in this regard. And so what you have here within this context, and we'll be covering it today, is multiple competing intersections and interests, right? That bring together issues of concerns about the right to freedom of expression, that bring concern, issues of economic interests, and sort of trying to strike a balance in terms of trying to move forward. That's what I said. At the core, this is really about a trajectory of governance.
And really thinking through this, and we'll get into this right now, is like one of the things that started this was this, there would be this proliferation of media reporting about, a worker doing X and then, being disciplined at work for saying something, doing something, sometimes doing things that we would all applaud, sometimes doing things that we would be very offended by, but recognizing that this was happening in an environment that, was kind of new, and we were trying to navigate this space. And, speaking only for myself, I went in as a scholar of labor thinking that there was going to be a lot of evidence of employers being really mean and nasty and workers being, angels. And I was quite naive to think that, because as we jumped into the cases, you realize that was true in some cases, but in other cases less so. So it became an interesting thing to think about how and this is where Dan's expertise really, I think, made the project so much richer, is this idea of how communication and technology is shrinking the space between workers' relationships to employment and their ability not just to have freedom of expression, but to be fully functioning human beings with thoughts and flaws and love and hate and like all the things that human beings have, and how that was actually starting to have an impact in the full development of working people as human beings whose workplace was now considered to be at home on a Saturday night, on a Tuesday morning, whether they were there or not. So it's really interesting to think about that. So Dan, I think it would be a lot of sense to just, what are some of the cases that we've looked at that really stand out for you? And And I think that was the initial grab for us, is like, wow, this is really interesting. And I cannot believe what I just read in that arbitration case. So maybe you could expand on that.
So yeah, we'll start with maybe a couple what we'll call sort of more legitimate cases versus some of the ones where perhaps the workers were not the sharpest tools in the box. Perhaps the case that most of the people joining us today are familiar with is the case of Carolyn Strom, the nurse from Saskatchewan, whose father had been in palliative care in northern Saskatchewan, and she had made some Facebook posts making some comments about the quality of care that her father had received, at which point the Nurses College, I forget the name, Saskatchewan, had basically took issue with her posting, suggesting that she brought the nursing profession into disrepute. They had fined her $1,000. They had asked that she write 2 self-reflective essays, and they then imposed $25,000, not court fees, but arbitration fees on her to cover the costs of the hearings. This went all the way up to the senior court in Saskatchewan, and the court ruled in her favor. In fact, she had done nothing wrong. In many ways, she was acting as a whistleblower. Her comments were in the public interest. At another level, we have another case that people may have heard of, is the case of Stephanie Kalitnikov. I hope I haven't destroyed her name, who was a former train conductor with CP Rail. And Stephanie also did modeling on the side, and she had photos of her taken on railway property. And yes, some of those photos were sexually suggestive and such. And she had also made some other postings on a CP Rail Facebook site where she had been critical of management. And ultimately, CP sought to dismiss her for unbecoming conduct on the basis of the photos that she had posted. Again, this went through the railway arbitration, and indeed CP lost its case. It ruled that they had no grounds for dismissal for conduct unbecoming. And the relationship between her and CP had been sufficiently damaged that that she was given additional monies in lieu as opposed to being reinstated. Perhaps we can move to a few of the not so clever cases. There's certainly one, the Charles, that you and I have talked about and sort of scratched our heads over a few times, which is the one here in the GTA of somebody who was a hospital worker, and there was a patient who had committed suicide while at the hospital, and this individual decided to take some photos and post those to Facebook and a couple of other social media platforms. That ultimately did lead to their termination for misconduct. Mm-hmm. I think perhaps the most egregious one was a case of a bus driver in the Chatham area. She and her husband decided to have sex on the bus and have people to have a third-party photographer take photos of it. The photos were meant to be kept just for her and her husband, but the photographer decided to post those online. Given that she was working for a small bus company, obviously her position, once those photos were found online, led to the bus company seeking her termination, not least because it was for school kids. And indeed, her dismissal was upheld also. Yeah.
So it really does show the like how the shrinking of space is occurring in between work and activity, some legitimate, some less than perhaps legitimate, easier to harder to defend. It exists on the spectrum, right, of speech. In Carolyn Strom's case, she was being disciplined not necessarily by the employer, but by a professional association that saw her activity or her conduct as somehow bringing the profession in disrepute. And we really have started to think about what that means, that the entire arbitration lens and then the legal lens looks at these activities through the lens of how does it affect the employer. So workers are already at a disadvantage in this entire new terrain because the entire legal system is thinking about how workers' activity bring into repute or disrepute the reputation and the brand of the employer. So it kind of starts at that level where you're already up against an incredible legal institutional system that sees the employer's reputation is more important than, or is more foundational than the worker's sort of abilities to.
I'll take it one step further, because one sort of nugget that we found sort of in our work so far that really hit home is that outside of La Belle Province, which operates on a system of common law, civil law, sorry, we're in a common law environment in the rest of Canada. And in the tradition of common law, an employee has no right to life away from work, right? Employment law within common law comes from, or was anchored in, or rooted in the translation of laws around domestic service and master-servant relationship, right? So the laws that we have now, the protections that workers have now, are really a case of positive rights that are coming into effect in this regard, right? And that sort of, we see right from the foundations of law in this regard, where you have that skewing process. This said, I think one of the things, again, that's been a surprise in some of the work that we have done is to see the extent to which arbitrators are actually sort of trying to strike that balance between employee interests and employer interests in a number of cases. Right? And I should point out, we should point out that one of the issues that we've had, or one of the limitations with our research, is that we're forced by, simply in terms of the information that's available, to focus foremost on unionized environments, because those are where we're seeing obviously the arbitration cases coming through. We don't see a whole lot of cases coming through the courts. We think for a lot of employees, for a lot of individuals, the idea of going to court because they've been dismissed for a social media post. I think a lot of folks that find themselves in those situations often are in rather holding precarious positions and such. And so the idea of going to court and the expenses that incurs.
Yeah, so the limitations of the methodologies are weak in that way, because the vast majority of workers, especially precarious ones in non-unionized firms, are not going to get the level of attention, and we're not going to have the breakdown of the arguments, and the legal regime will not kick in that way. So that is a limitation, although we do have sort of evidence that, and this is sort of anecdotal in the media, that this is occurring perhaps even more aggressively in the non-unionized firms, because employees have very little abilities to protect themselves from unilateral employer decision making. So this is probably a good time to introduce some of the legal institutions that we are talking about. Dan, do you want to go through some of that?
I'm sorry?
The legal institutions, so specifically the Milhaven and the Goodfellow Test.
Yes, right. Okay, so for those that find themselves in this situation, there's basically 3 assessments that are done. The first one is called the Milhaven Test. And the issue here in this context, if you find yourself in trouble for social media postings, the Milhaven Test is set to assess the extent of to which your out of workplace context affects the workplace. So there's 5 questions that are asked in this context. The first is whether the employee's behavior harms the company reputation. And very important here, again, it speaks to the skewing that Charles was talking about. The company does not need to prove, or the employer does not need to prove, that they were actually harmed. The mere fact that harm could potentially be caused is sufficient grounds for action. The second element in the Milhaven Test is that the behavior of the employee renders them unable to perform their duties for the employer. Third, related to this, is the idea that perhaps other employees refuse to work with the individual in question. The fourth possibility is if one is guilty of a serious breach of the criminal code. And lastly, is whether the employee's behavior creates difficulty for the company in terms of impeding its ability to perform its duties. Now, in order for relationship, outside workplace to be seen as having a link to the workplace, we just need to identify one of those criteria within the Milhaven Test. Now, the Milhaven Test is pretty broad. So at that point, there's another question that sort of comes in, another test, the Goodfellow Test, that comes in to try to counterbalance a little bit more egregious uses of Milhaven. And the Goodfellow Test consists simply of 2 questions. The first is, in looking at a situation, what would a reasonable, fair-minded individual who has access to all the facts think? Would they think that the company's reputation or the employer's reputation would be seriously damaged? The second element of the Goodfellow test is, would the continued employment of the individual in question so damage the employer's reputation that the employer would no longer be able to render the services that they are meant to render, right? Now, one of the things that comes out in this Goodfellow test is this third test, where the question has to do with the type of discipline that's imposed. And one of the things that we've clearly seen across the board in our research is employers seem to be going whole hog in terms of trying to go for the strongest level of discipline that they can have, i.e. dismissal, right? So the first question is really sort of hey, was the violation, the act, meriting of discipline? Second question is, did the act justify dismissal? And then the third question is to say, well, if dismissal was not justified, was not just, what are possible alternative courses of action that we can see? And this is one of the things that we are seeing, I think, in terms of a number of the cases that we have looked at, is there's a number of cases where people have been dismissed. But we see an awful lot as well where the arbitrators are ruling on the one hand in favor of the employer's claims, but on the other hand, they're rolling back the level of discipline that is being imposed upon the employees.
Yeah, arbitrators seem to be really nervous about the sort of so-called nuclear option, right? Of like just absolutely moving to dismissal at the sort of first instance. There's also some really interesting, I think, problems from a social science perspective about how arbitrators are trying to navigate this regime by calling this Goodfellow test, which occurred out of a school board. And that's the other thing, like the private-public divide. What does it mean to bring the public sector into disrepute in the eyes of the public? And that gets really subjective, I would argue, especially when it comes to the types of services being provided. So you can imagine healthcare or education being ones that are quite vulnerable given privacy information. So that's been an interesting one. But what's interesting is the arbitrators want to argue this is an objective test when it clearly is subjective, right? So like they can't objectify, sorry, that's not the right term. They can't make the test so clear-cut and rule-bound given the complexities of these situations. So although arbitrators, I think, are trying to do their best, right, they're still filtering it using their legal training through this lens that I think puts workers at an automatic disadvantage. And one of the reasons why employers are going nuclear almost in every instance is because it not only will have the effect of maybe getting rid of the employee or disciplining them, but it's also going to send a warning to all of their workers, like, you better watch what you say, because this is something we're watching. This is something we're going to take action on. And one of the things that Dan pointed out in this paper we recently wrote that I thought was quite astute was this idea that that this is happening not just in the middle of an employment, but it's happening before you even get hired, which we can't trace, of course. So they're doing searches on you before you are even a formal employee, and that might be having some implications for your ability to be employed. So all of these things are happening at multiple levels, and some of it's hard to trace.
And I think the aspect, just to come back to your point, that I think is really key is that, yes, an employer doesn't need to necessarily dismiss an individual employee for their social media points to win, right? All they need to do is sufficient to train the other employees to be sufficient, to not engage in that type of behavior, right? So a chilling effect within the workplace. If we often speak in sort of concerns about journalists being, holding back and self-censoring and chilling in that regard. And I think we have that aspect in the workplace. There's also another very important aspect in terms of the training. You spoke about training, Charles, that comes into play. And I think it has to do with the spatial dimensions of this, right? Training employees to begin to internalize the idea that it's not because I'm not at the workplace that I'm not necessarily in the workspace, right? So this idea that even though I'm at home, physically I'm not in the workplace, but the minute I'm online, if I'm posting things, my employer has access to what I'm posting, and not just what I'm posting, but also the responses that my network of friends and colleagues and professional associates online have access to. Mm-hmm. So there's a dual, actually there's multiple levels of training that are going on at this place. But I think it's sort of this idea of sort of, changing consciousness, if you will, right? So if we think back in terms of, good old E.P. Thompson and Nigel Thrift and stuff, and writing about sort of transformation in the English working class and stuff, changing sort of people's attitudes and thinking about work from the, from a feudal agrarian economy to an industrial economy. Now we're seeing it as well within the context of from, an industrial economy to a more digital economy, or,
Yeah, hearing E.P. Thompson is like music to my heart, so I appreciate that bringing that up. And it's really fascinating too, the way that and I actually have some sympathy for arbitrators because I recognize the complexity of this work, but in some of the cases there was some discipline issues around firefighters in Toronto, and what was fascinating is the arbitrator was really struggling to say, like, okay, so a firefighter did X, tweeted X. Did the firefighter's profile identify with the employer? So in other words, was the firefighter wearing, in this case, it was his uniform, and one of them was and one of them was not. So the public would more closely identify the one who was using the picture as a firefighter. You could demonstrate what that person was doing, as his connection to the employer was considered more closely aligned. So so they have to really get into the weeds on this to say, okay, well, what's the relation? But I think the thing that we keep coming back to is it's always through the lens, and I know I've used that analogy a lot, but it always is through the lens of the employer and the employer's image and the employer's brand. And I think it's really important as a starting point to think about how to address this, is that workers need to be aware of that. And one of the other things that, Dan, you also pointed out, and again, quite astutely, is that we've been to some legal seminars as researchers, and we've seen management side lawyers trying to address this and get in front of it. And they always recommend the same thing. They always say, have a policy. They have to have a workplace policy. The policy is going to save you. And what Dan discovered in his uncovering of some of this is that the policy is almost never referred to by arbitrators or even their employers' lawyers. Why do you think that is?
Well, because they have there's a couple different things that come into play. I mean, they have different codes of conducts in place, the things relating to behavior, to workplace violence, to anti-harassment, these sorts of things. And the notion of when you go through the literature and you see the sort of circa 2010 to 2015, when this was sort of coming to the fore, and at the time too, a big concern was about gripe sites and blogging and the implications thereof. But the default position was companies need to set up a social media policy. I think one of the dangers with setting up a social media policy, of course, is that it becomes perhaps more of a lightning rod for concerns about limiting freedom of expression more directly. Whereas I think, again, I'm speculating here, but I suspect that for many employers who have other policies in place, it's more effective and efficient for them to seek disciplinary action through the other measures that are in place, as opposed to a social media policy, right? So the issue harassment doesn't take place just in the physical realm. It can take place online. So if we have a harassment policy, then perhaps we can apply in that regard. And that's become much more the norm in terms of the arbitration cases, where it was really surprising to see how few actually refer to social media, violations of social media policies, as opposed to violations of other types of policies in this regard, right?
Yeah. So one of the things we've been able to map, just some raw data, is that this has really exploded in the last 10 years. People might not be surprised by that as social media has become more and more pronounced. So 2016, 17, 18, and 19 were the highest years ever. And there's been a bit of a decline, but also there's probably a backlog of arbitration cases that might be coming. So this is a fairly...
I can attest to that fact, having been on Uncanny recently. Yes, there's a backlog being published.
Yeah, so we're playing a bit of catch up in the more recent years, but it's certainly an ongoing issue. And just to share a few more stats with the audience, most of these cases are coming from Ontario. It's probably not surprising, although Dan has identified some interesting differences in Quebec. And I think at this point, there's still something to think about. There's not enough to really demonstrate that this is an anomaly or something different, but it's probably worth highlighting. Do you want to speak to that a little bit?
Yeah, so amongst the key arguments that employers use to seek disciplinary action for social media postings, one is, defamation, second, insubordination, and third, duty of loyalty, right? So and one of the things that we've seen, and again, I wouldn't go out on a limb on this because I don't think we don't have enough data to begin generalizing yet, but the limited data that we have would suggest that there's a much more stern approach to thinking about duty of loyalty within the French, or the Quebec system, as opposed to the rest of Canada, right? So again, and perhaps that's to do with different interpretation between civil law and common law. The other thing as well, Quebec's defamation laws tend to be more certain, if you're seeking damages for defamation, that it's easier to obtain those through the Quebec system than it is, say, in Ontario. So we've, these sorts of issues, again, there's possible sort of trajectories that some of our research findings are pointing out to. Interestingly, just to come back to this in terms of, backlogs coming online, there's a whole slew of cases from Quebec that have just come online. So that we need to wade through, so that perhaps this sort of this hypothesis that we're seeing, or this sort of forming hypothesis, might be validated or not.
Yeah, that will be interesting. And for those of you who are new to this area of law and politics, the duty of loyalty, Harry Glassbeck's written about this in a lot of his work, and his work is excellent. He's got a little book that I've assigned to some of my students called Capitalism, a Crime Story, where he talks a little about the contradictions in how law regulates economic actors versus individuals or groups outside of the economy, as it were. He talks about the duty of loyalty, and one of Glassbeck's observations that this is a throwback to the master-servant laws of the 19th century that continue to plague our regulation system. The idea that somehow workers, because they are in a paid relationship with employers, somehow owe a legal obligation to them is a throwback to the old feudal idea of workers literally being servants of their masters, as it were. And some of those attitudes are very persuasive in the legal literature and the legal arguments being made. And one that I think we do have to sort of start poking some holes in, because it does demonstrate that it's an anti-democratic idea. And it's certainly not one that I think should be driving decisions in 2021 when we pat ourselves in the back as being a fully functioning democracy where we don't have this legal obligation in a way. But yet that's still, and this is, of course, I'm quoting and not doing it very well, Glassbeck's sort of arguments, that it doesn't really align with our modern day arguments around how democracy should work. So all apologies to Harry that I've probably totally taken him out of context and misquoted him. But I mean, it's so worth pointing that out, I think.
And it takes on heightened dimensions, obviously, in terms of, if we think in terms of how integrated digital technologies are in our everyday lives, that we're pretty much always connected. And in that regard, in that sense, we do become sort of de facto PR reps for employers. And that's kind of the duty of loyalty concern for employers, where they see, hey, and we see this not just employers, we see this with universities as well, where there's concerns in terms of, whether it be faculty members, whether it be employees in a place, representing the organizational brand and the organizational reputation. And in the current times, I'm not saying anything new by suggesting sort of, there's heightened sensitivity to brand and reputation in ways that perhaps we haven't seen before.
And as universities become more corporatized and neoliberal, we see more and more of this in the public sector, like in universities, hospitals. This is going to be actually one of the defining, I think, labor issues in the next 10 years, especially given the pandemic has sort of driven so much of us to online work. And now employers are starting to talk about how online work is either going to increase or diminish their productivity. And that, when you start talking like that, what they're really saying is we can't monitor employees in the same way that we're used to in our office location or in our physical location. And employers are going to be pushing for, if there's a push for more online work, for greater ways to discipline and to monitor workers in their own private residences. So at that point, their private residences become an extension of the workplace. To think about how powerful an employer's role could be if they had the ability to monitor you in your private home around productivity issues is really important for us to think about. And unions need to get out in front of this, because it's going to lead to problems.
And it's already happening.
Yeah.
They can trace us in many cases. So depending on the platform you're using through which to connect to the workplace, it's pretty easy to monitor what you're doing to track your productivity and such, right? There's a great report that's just been published by the European Commission that was authored by Professor Kirsty Ball from St. Andrews University in Scotland. I haven't had time to go through it in detail yet, but that touches precisely on this and big concerns in terms of the psychosocial implications for workers who are being monitored in this way. Right? I think, side with the union thing too, I mean, I think one of the things to begin to think about in this regard is a variation on one of the great benefits that you and I benefit from in our professional lives, and that's academic freedom. Our speech is protected in ways that it's not for other workers. And yes, there's debates about where the sort of the boundaries, where does academic freedom end and freedom of expression begin and such, and but it is a privilege that we have. And I think that one of the things that we do need to begin thinking about in terms of unions getting out front is this question in terms of what additional measures can be put in place to ensure the protection of workers' rights to freedom of expression and of workers' voice. Right.
I mean, I think it's almost at this point, I think we can agree, we've discussed this a lot and talked about it, and just as an extension, is I think it's time that unions put at the front of their bargain, or at least in the middle, or the front or the middle, or somewhere in their bargaining proposals, that they want to have discussions about freedom of expression and workers' ability to disconnect from the workplace and not to have their activity front and center by employers. And if they start doing that, then it's grievable, right? At least it gives the unions a legal capacity to push back against this greater and greater intrusion. Is that going to solve the issue? Absolutely not, right? It doesn't solve half the problems we've pointed out here. But by doing nothing and leaving it to the employer to develop a policy and enforce that policy, whether it's that policy or something else, is always going to put workers at a further disadvantage.
Well, we have a possible opportunity in terms of the new proposed legislation in Ontario, which is based on the French legislation, right? So, but the proposal to establish the right to disconnect. Now, the right to disconnect in terms of how it's presented for the most part is it would guarantee that one's employer can't email them on the weekend, for example, right? And it would ask employees to sort of, as some of us do now in terms of our messages, say, sorry, I'm away, I won't respond to your email for another 2-3 days or whatever, and inevitably you still respond in 5 minutes if you're
yeah, that's right.
but what you don't hear, and this is where I think the avenue comes in terms of the right to disconnect, is so if I have as an employee, if I have a right to disconnect, meaning the employer can't send me messages, can I disconnect enough from the workplace so that I can speak my mind and voice my concerns? Right? And I think that that's kind of an avenue that merits further consideration, further thought, because the disconnect is not just the employer being able to send an email or ring me up or something. That's not, the disconnect actually is to cut the cord, if you will, from all the data monitoring at that point, right? So that in fact that the employee potentially does become more autonomous in this regard.
Yeah, I mean, and one of the things we saw, so we have some really funky graphs that I think Dan mostly did without my input, and they're just fantastic. But one of the things that we've discovered is that right now it seems like the discipline is really being pushed by whenever an employee touches their toes into mentioning the workplace, which for public sector workers becomes a lot more blurry. But we're not seeing, for instance, a lot of employees being disciplined for, I think Doug Ford is a terrible premier, in their own private time, or you should totally vote for, Andrea Horvath, NDP, or we should do some Western content, I think, here too, right? And John Horgan's the worst, or he's the greatest. Like, we're not seeing a lot of that type of discipline, where it really does. I think the trigger is always when it borders on or starts touching the line between an employer's business, or but it's worthy of the question. Will that always hold as we get more and more into this like sort of online work environment, where I think for the vast majority of workers, there's going to be online components, and it's curious if we are on a, and I don't love this analogy because it's overused, but if we're on a bit of a slope, because the graph that I'm speaking to, Dan, is figure 5 in our paper, where it's like the motions of so mentions of the workplace are 26% of all disciplinary actions. Mentions of supervisors are 19% of all disciplinary actions. Some sort of post has been identified back to the employer or the employee, but connection to the business. Only 10% of our database, that's admittedly always changing given that these cases keep coming, but only 10% that we've identified are comments that make no direct mention to the workplace. So there is still, I mean, that's a sizable number. That's over 10 cases in a 100-case database. But at the same time, the vast majority are making that direct connection. So it's worth kind of thinking about whether that 10% holds or whether it starts to expand as we get into more of this type of work relationship.
And it's fair to say about that 10% that, they were for really egregious racist commentary, homophobic commentary, and in one case, expressions of support for terrorist actions. Right. So they're at the far end. It's not just sort of saying, hey, vote for so-and-so or don't vote for so-and-so.
I don't think we've seen a case like that.
No.
So, I mean, and that type of behavior is indefensible.
Yeah.
But, some of the labor lawyers we've talked to is the action of firing the only solution, or does there need to be mandatory sensitivity training, anti-oppression training? Is that something that should be negotiated as opposed to any time? And of course, that action is indefensible. Nobody can defend that. No one should defend that. But what I think is worth thinking about is as comments get more and more closely tied to the employer, or there's a sense that, so if you're supporting a political party on the far left or the far right, and it gets back to the employer, how long will it take for that discipline to start? So you start thinking about these things in ways that, again, I don't love the analogy because it's overused. And my first year philosophy students love the slippery slope argument when it comes to freedom of expression and John Locke's work, and Mill, but it's fine. It's a good analogy but it always sort of lends itself to being easily dismissed because, well, you're overreacting. It's not a slippery, but I am concerned about the physical space and how space and time are being squeezed so closely together.
But I think I think that's why it's important now. We're fortunate in the sense that I think we're at the right moment in terms of now's the time to take stock of what's happening and what are these sort of contending processes, rights and interests that are all intersecting.
Yeah.
To sort of measure that. Because I mean, the other aspect of this, we've been talking only about cases today that sort of directly involve somebody articulating something about their employer. But one of the things that we've seen in terms of selecting our work as well is the vast number of cases where action in workplace discipline is not being taken necessarily because of something one has said, on Facebook, on Twitter, or whatever, but rather it's the Facebook activities, the Twitter activities, the other social media that are being used as evidence to support a case.
Yeah, that's a good point. Yeah.
You've been accused of doing something that merits discipline, and we have all this other evidence, so that the social media posting becomes part of the dossier to make the case for why disciplinary action should be taken.
Yeah, like the backlog of your history.
We've seen a number of cases of that, and nobody's won any of these cases yet, but involves people sort of, having put in a request for holiday leave, not getting the holiday leave from the employer, so then putting in a request for bereavement leave, getting the bereavement leave, going on holiday, and then posting holiday snaps on their social media profiles, in which the employer, catches wind of that, and then of course disciplinary action is sought. So, I think that there's part of the challenges for working in this area too is the diverse ways in which the platforms can be used, right?
Well, I like that you brought up that the idea of the history being so important too, because we see it in the political world when some candidate that was trying, all the parties are vetting candidates like crazy now, and rightfully so. But what's interesting is sometimes candidates are being, because we've been living with social media now for over a decade, so especially if you're a younger person and you sort of came of age in this time, there's probably comments you made when you were 18 that you might not like when you're 28. But when it comes to the cases, and so this is only going to get worse as social media expands. There's multiple platforms now. Likely there'll be more. So what you're saying when you're 16 could come back to haunt you when you're 45. And not in the political world, but like in any sort of employment world. And that's the longer term thinking that I think you're highlighting with this physical time.
And it's another sort of instance of of thinking about weighing the benefits and the pros and cons of a right to be forgotten.
Yeah. So it's a really good, which is another area. Maybe you want to expand on that, and then we should probably turn to the audience who might have some questions.
Yeah. So so your European law is at the forefront of this in terms of the right to be forgotten, so that within the European context, one can have their information removed from Google searches and from other social media platforms and such. And it's an ongoing issue because it has economic consequences as well, in terms of data collection and whatnot. But it's precisely this case of saying, hey, on the one hand, I did something stupid when I was 16. I don't want photos of that coming up on Google search all the time. But you have other cases too that are not quite so clear cut. So, use an extreme case. One has a conviction for drink driving. They were involved, a conviction for drink driving, and somebody passed away in an accident.
Mm-hmm.
15, 20 years have passed since that. Should that be something that still comes up if you're searching for somebody online, or should they have a right to be forgotten in this regard, right? So that opens up a whole Pandora's box of issues as well.
Sure.
So there's, but when it comes down to this, right, if you, I think much of this work in this area too is going to be not just freedom of expression, but increasingly concerns around privacy as well.
Yeah, absolutely.
Right?
Yeah.
The intersection.
And I think the Pandora's box you're speaking to really does. I mean, I think that's the one surprising notion of this research for me, and is that the complexity, right, and the multiple areas it opens up when we start digging a little beneath the surface of how much is being covered and over how much period of time, and how much we are at this moment transforming our social and material realities to adapt to this new interface, which arguably has been accelerated by the pandemic and how we've tried to build community and work through this online sphere. So there's some irony, I guess, that we're doing this way, this event over this, because it's changing our space. I'm in BC, you're in Ontario, and we're interacting, and our audience is from over the country. It's a microcosm of what I think we're talking about. And we're at about 10:02. Are there questions from the audience that we might want to field, or does any comments, anything we'd like to share with us? We'd love to hear it.
Yeah, I do want to remind all the attendees you can use the Q&A button to ask a question now. And the first question is from an attendee, and they asked, to what extent does the rule of precedent currently influence the court decisions related to outside workplace employee misbehaviors?
So, if the questionee or person who wrote the question, I'm curious what they mean by inside outside work. So is it just physically like doing work like on a construction site versus doing office work, or maybe they could clarify that? Dan, did you want to?
Yeah, I interpreted it as being sort of being in the workplace versus out of the workplace.
Oh, okay, that makes more sense. Sorry, I apologize if I misinterpreted that.
And it's been pretty much accepted as precedent since about 2014 that off-duty posts can be considered as workplace conduct that's subject to discipline. That's kind of an accepted starting point. The issue, of course, then becomes sort of subjecting those off-duty posts for disciplinary purposes to the Milhaven Test and then the Goodfellow Test in terms of how we proceed. But yes, at the moment now, it's more or less accepted as precedent.
And worth pointing out that the Milhaven and Goodfellow tests both predate social media, right?
Yeah.
I think it's really important to recognize that. So those cases were dealt with like letters to the editor or some other form of, like, I'm going to just say old communication technology versus the new that we're now currently involved in. So we've talked about this a lot, Dan. It's worth pointing out that the precedent that's being applied to this new environment is an old one that deals with, one's from the 1960s and the other's from, I want to say the 80s or 90s, like predates.
Milhaven 66, I think, or 67.
Yeah, the Milhaven test in particular. Yeah. So it's interesting that arbitrators and courts and lawyers are using precedent that predates the social media world to the social media world. So that's an interesting one to point out too. And I hope that gets to the precedent question of the question. Was there a second question also there, Ange?
Yeah, the next question, did you come across an example of an effectively elaborated, implemented, referred to workplace behavior policy within your research? If so, how was it different from other less efficient examples?
So the policy around social media use. Yeah, so we have been collecting these. I'm curious, maybe you want to take that one, Dan.
Hodgepodge. I think this was one of the striking things across the cases was that, as many employers as we have in the databases, as many different policies that we have.
Yeah.
Right? The policies are kind of designed to the workplace. And it makes it really difficult to try to compare them across the board because, if one wanted to try to pursue a social media policy in organization X, it likely would look rather different than organization Y. There may be sort of general principles in place and such, but I'd be hard pressed to say that I found sort of one efficient or one effective policy that sort of really stood out at this point.
And the best ones that seem to be effective are ones that the employer does in consultation with the union. And I think there's sort of a buy-in on that level. Whether or not that's more effective or even more just is, I think, up for debate. But when employers bring these down unilaterally, consulting their HR professionals and their management side lawyers, there tends to be less buy-in. Unions aren't going to act as tools of education when it comes to these policies. They're not going to help enforce them. And I think there's contradictions when unions do that, when they do buy in and they do start helping employers enforce them. And it's not universally the right thing to do. It does lead to tensions and contradictions within how you best represent your your members. And unions, I think, are very conscious of their DFR representation or duties, so their duty of fair representation, that they have to represent their employees, which leads to both, again, I think it's contradictory because unions are defending some of the more egregious behavior that we've talked about. And, we've seen it quite prominently in the pandemic when unions have come out publicly saying they will not enforce and they will not defend vaccine and mandatory masking. And of course, it's way outside with where the public is. So it lends itself to all kinds of tensions and contradictions that the legal obligations that unions have. And how they're approaching this, which is why I think Dan and I are in agreement. Correct me if I'm wrong. I don't want to put words in your mouth, Dan. But that the unions have to get in front of this, right? They can't let the employer set the terrain, because they're already at disadvantage vis-a-vis the legal regime. They have to get out in front of this, whether it's through bargaining, whether it's through another means. Bargaining, to my mind, is the most effective. Without being in front of it, they're just constantly going to be at the whim of the employer's sort of policies or actions.
Because I think, to build on that point in terms of getting in front of it, what we see in some of the cases that we've analyzed so far is, protection for the workers through the collective agreement, right? And having to go through that process, the arbitration process through that regard. But in most of these cases, again, sort of the assessment of the discipline was through existing articles in the various collective agreements, in different policies and such. And to the extent that that's true, it's almost an aspect of reacting to the social media environment, right? In terms of reacting to posts in these contexts. And so it is, I think, getting in front of this, of thinking about, what would it look like to have what I'll call additional sort of voice protection measures for employees in a collective agreement. Would that be possible or not, right? And it comes back to what I said earlier. I think, to my sort of early thinking about this, is I think the entry point that we have is this disconnection legislation to allow the employee to fully disconnect, not just partially disconnect.
And there are things that workers can do proactively here to avoid this. And this is it's funny. As we did this sort of things research, I started changing how my profile was on certain. So Twitter, I like Twitter, and Facebook are the two that I would primarily use. It's interesting to think about the forms of communication that are more visual based, like TikTok, that I'm not as active on, or Instagram. But it's like things that workers could do right now would be, if you have a profile that says I work for Ontario Hydro, take that out. Right? Do everything you can to not associate yourself with your employer in your online footprint, because that will inevitably be used against you if you're ever up against a disciplinary hearing for stuff you said online.
Yeah.
And the more you can, and the arbitrators will put that on a spectrum. How closely do you align with your employer in your online world? So if you are Firefighter, don't have pictures of yourself on the job wearing your uniform if you know, or whatever. Workers can take that easy step to protect themselves a little bit. But again, it's not going to be a complete shield, but certainly that is one small area that workers can identify with. So that's worth thinking about too.
Professionals also, I think all around, in terms of the moment that if you have on your Twitter bio your professional affiliation, for the purposes of discipline, you're linked
to
your employer at that point.
Yeah.
And then the issue becomes in terms of, again, this assessment in terms of how much additional strength does that give to your voice if that identification is there. So if I'm a medical doctor and I have, medical doctor is listed in terms of my bio, and if I'm posting anti-vax information, the argument there's cases that we've had in terms of the College of Doctors and Physicians where that's been precisely the case, where individuals have claimed, no, it's my private Twitter account.
Yeah.
And the College of Physicians has come back and said, no.
Yeah.
The fact that you have that in your bio gives additional strength to the claims that you're making.
Yeah. And if we could make additional plea for medical doctors to stop tweeting out anti-vax material, that would be great. We'd like that also. But are there any more questions, Ange?
Yeah, the next question from Rona. Rona says, as Daniel said, in universities where you work, faculty are supposedly protected by academic freedom, which does not change your obligation to do your job, but which means you do not have a duty of loyalty. Have university administrations monitored faculty social media as is happening elsewhere and tried to discipline them? If so, what happened?
So Dan, you've been doing some work on that, so I will totally hand that to you.
All right. So the one sort of the big case that's sort of close to home, because where I'm based out is the University of Ottawa, where we had a certain professor who was posting all sorts of anti-Quebec messages and making comments about sort of the premier and whatnot. And lots of issue there as to whether sort of academic freedom extended to this individual or not, given that these posts were not in his domain of expertise. This individual did have on their Twitter profile that it was their own account, that they're speaking for themselves, not for the university. But that's still very much being debated. I'm not familiar with, perhaps some of the people listening would know better. Apparently some sort of message has gone out to faculty at the University of Alberta with regards to how they need to structure their messages and whatnot, their email and their social media profiles and such. Apparently McGill, I'm told, may have something along these lines. I was going to say just quickly, sorry, the issue, much of this falls under that sort of the academic freedom debate. Yeah. And then, of course, the issue with academic freedom, that the key decision there, which came out from New York a couple of years ago, is basically the case where if the university does seek to take action that could be infringing on one of their faculty members' academic freedom, the test there is that, are the university's actions such that they would impede another reasonable employee from speaking their mind?
Yeah.
So,
and there's several areas that we're thinking about in the university sector that because we don't study that particularly, so there are people that would be better able to speak to this. But what we have noticed is, so when some professors weigh into very, heated academic and political debate, such as the Palestine-Israel question, there's been issues. Because Canadian universities are so heavily unionized and COUT plays a significantly important role in protecting faculty members, that quickly gets flagged and they push back quite hard. So there was the case at UT where they were going to hire a professor, decided they pulled the offer, and it got really ugly. So like that example is real, but again, kind of exists even outside of social media. In non-unionized sectors like in the US, this happens all the time. And then, of course, when we look at the political economy of academia in 2021, tenured and tenure-track faculty have greater levels of academic freedom protections than precarious sessional or adjunct faculty, who I think are under a much much tighter microscope in terms of having to reapply. So they have to also watch that probably a little bit more closely. And academic freedom cases are not as, there's not as many of them because I think that they're so vulnerable, and I think that there's a lot of self-discipline happening there too. So it's an incredibly sophisticated, important policy that obviously as academics, many people wouldn't want to be doing this if we didn't have that shield. But at the same time, it's not a perfect shield because we see all the holes in it. And it's as universities are corporatizing and becoming more brand conscious and competing for incredibly shrinking dollars by the provincial governments, they're becoming and acting much more like private corporations. So I would expect, I'm sure Jim Turk here could expand on this as his history of COUT, that we're going to see more of this.
But I think the key thing as well, Jim, is just the academic freedom thing quickly, is that there's a surprising level of lack of familiarity with the whole idea of academic freedom, even amongst faculty members. Right? We all have some less disagreements about what it is not, what it entails, the protections it affords, the protections it doesn't afford. But the one thing that I think, the additional thing I think many people overlook, and Charles will use you and I as examples, is that our two institutions have very different definitions of academic freedom in their collective agreements. And within the academic context, we are beholden to how it's defined in our collective agreements in our place of employment.
That's right.
And that's really kind of the key thing. Because even as an academy, there's not sort of a common, clear acceptance of what it means.
That's right. Yeah.
And the two sort of key definitions that are in play at the moment, one's the UNESCO one, and the other one that goes back to the Supreme Court decision, pertain really to, again, much earlier times, the before times.
That's right. Yeah. So, Ange, are there any more questions?
Yeah, the next is from an attendee, and they say, I work in a non-union workplace as a childcare worker. Is there anything I can do that lets me be a political activist without putting my job at risk?
That is such an excellent question, and the dilemma is very real. I sympathize with this person's question because right now, I'll speak briefly and then I'll turn it over to Dan, but right now in a non-unionized firm, there's very little protection you have in terms of your rights outside of the workplace if you're identified in any way or if you're well known enough to know and tie yourself to that employer. So there's some, if the employer randomly was trying to discipline you for something, there are some protections in the Employment Standards Act, but outside in various jurisdictions, but outside of that, it's thin ice, and that is a reality for non-unionized workers. Now, having said that, we don't see a lot of evidence of people being disciplined for political positions that are taken outside of their workplace, unless your employer is the government and you're tying government policy back to your employment. So there's not a lot of evidence that employers are nervous about political behavior in terms of their own reputation, but it's not impossible to imagine that, especially if your employer is the government. Dan, I don't know what you want to add to that.
No, I think there's not much to add other than to say, ensure that your social media activities do not connect you to your employer in any sort of visible way. The concern, of course, would become sort of, I think, Charles, as you touched upon, is this question of whether your activities might be seen somehow as undermining the reputation of your employer, or would render your ability to be an early childhood educator ineffectual. Right? Would you not be able to do your job if word got out that you were being politically active?
Which, I think we can all agree that's wrong and it shouldn't happen, right? But, we have an entire legal regime, employment regime that, again, filters its entire reason for being through the lens of the employer. So we have to start with that basic understanding that we already are up against an entire institutional structure that sees you at the bottom of that hierarchy.
And that's why, it's like you said, it's especially so if you're in non-unionized environments.
Yeah. So my definitely my sympathies go out to anyone who wants to be politically active and is worried about it, because it just seems to limit your capacity as a full citizen in a democratic society. Ange, any more questions?
Yeah, the next question from Natalie. You mentioned the Goodfellow criterion, which includes what a reasonable person would think. I know this is supposed to make the decision objective, but isn't the determination of reasonable itself subjective? What an elite white male judge sees as unreasonable comments on Twitter about an employer might seem entirely reasonable to a racialized woman working at a minimum wage job in a large corporate warehouse.
Oh, 100%.
Absolutely spot on.
Yeah. Couldn't agree more.
Yeah.
Absolutely. Yeah. The whole reasonableness tests are always, I think, not objective. They are 100% objective. And I think that the question and the writer of the question is spot on that point. But Dan, please.
No, ditto is about the only thing I can say. No, I completely agree. That becomes this key thing, because we're at that point, the test of objectivity is based on an imaginary. And as you rightly point out, there's many differences in terms of what we may see as reasonable. I couldn't agree more strongly with the questioner.
I'm just trying to find the Milhaven language. If I could, I have it written down here. If bear with me for 1 second. But it does make that point. It specifically says it's objective test in that it takes out the personal. When I think we're dealing with very strict behavior that is very personal. So you can't really take out that human element that the courts and I think the legal system wants to do. Now, of course, I can't find it as I'm looking for it. Sorry, but
I'll have it in just a second here.
But the objective nature of it, I agree completely. It's much more subjective than it is objective. I had written it down, I had it here, and now, anyway, all of that to say we agree with the commentary. It's very much the case that these tests rely on that sort of bias.
I have the language here if you want.
Yeah, please.
Okay. Of course, now I've got the spinning circle.
Well, what we're looking for, maybe we'll take another question and we'll just come back to it. Is that okay, Ange?
So, I can read it to you. I've got it here if you want.
Please.
Okay. So this is from the Ottawa Carleton District School Board, Ontario Secondary School Teachers Federation, District 25, COB 2006, the decision. And the decision was about the school board's right to protect its reputation. And so the reading is as follows. This does not mean, however, that the school board, unlike other employers, is entitled to be the custodian of the griever's personal character or conduct. Employees of school boards, like other employees, do not surrender their personal autonomy when they commence the employment relationship. In order for an employee's off-duty conduct to provide grounds for discipline or discharge, it must have a real and material connection to the workplace in a manner described above. And where the interest asserted by the employer, as it is here, is in its public reputation and in its ability to be able to successfully carry out its works, the concern must both be substantial and warranted.
So it's broad.
Here's the key point. The test, so far as possible, is an objective one. What would a reasonable, fair-minded member of the public, in this case, the school community, think if apprised of all the relevant facts? Would the continued employment of the griever in all of the circumstances so damage the reputation of the employer as to render that employment impossible or untenable?
Yeah. So reasonableness is the standard, and you can see how reasonableness is. And in administrative law, I know there's a spectrum of what reasonableness is and how they try. But again, I think it does speak to problems about it, of trying to make this an objective test when it clearly is a subjective one. Yeah, I think we agree on that. I hope that gets to the point of the question. Then thanks for that. Andrew, are there more?
Yeah, the next question is from Carolyn, and Carolyn says, I agree that the employer-employee relationship is based on feudal ideas. I am really concerned that this feudal idea is in the process of being extended to universities. If when that happens, freedom of expression concerns become academic freedom concerns. And once even the university is subject to restraint on expression and thought, we would surely witness employees in other workplaces being subject to even greater restraint. And academic unions can themselves be really repressive. They too talk of the brand. How then do we get out of this mess?
Whew. That is such a good question and so hard to answer. Dan, how about you take that?
I think I don't know how to answer that question other than to say I think in terms of part of getting out of this mess, and I don't want to trivialize it. I think part of getting out of this mess is really taking stock of where we're at. What's amazing right now, I think what struck me the most in the research being done in this area right now is how very limited that work is. And what I mean by that is we see an awful lot of legal analyses, we see a lot of normative argumentation, but we see surprisingly little empirical research that's seeking to map out the terrain of what's actually happening right now. And I think that part of the way of going forward, of course, the more normative arguments, the legal interpretation, that's all key, it's all important. Mm-hmm. But I think we overlook or we avoid the empirical component at our peril.
Yeah. Mm-hmm. One of the things that you pointed out, Dan, that I was really surprised by, and I hope this gets to the heart of the question a little bit, is that in the legal community and arbitrators, for the most part, I think see this as a non-issue anymore, right? There's an established precedent, and this I hope gets back to some of the questions on precedent that were asked by some of the attendees. They feel like there's a model now that they can filter it through. Surely there'll be new issues, but they, it's almost uncontroversial when we talk to some of the legal people these days. And in our minds, we're at the very much at the foot of Mount Everest, and we haven't even really started climbing yet because this is so new to really understand how it's transforming our lives. Mm-hmm. And then to think about the university sector that the question directly tied to is the universities. We're starting to see universities trying to get in front of this as well, as they are becoming more and more tied to competing for limited dollars and students, etc. That it will inevitably, as they try and get in front of this, start pushing back against academic freedom. And unless it's vigorously defended, it will be eroded, right? And I completely sympathize with the argument that university unions need to be more, inclusive of their membership. They need to sort of be better at communicating. All of that's true, and distance themselves from the brand completely, because I think that just ties into some real problems. But yeah, I think, as you mentioned earlier, Dan, really thinking about what academic freedom means and how we want to defend it, I think is essential too, especially as we're navigating into whole new terrains of social interaction.
And I think one of those elements going forward that goes with branding and with reputation and with other social interests as well is this question of does academic freedom get balanced against other competing values? Mm. And that becomes sort of a key concern. I mean, it's one of the things in terms of where I'm based out of the University of Ottawa. They released on Thursday the Bastorat's report on academic freedom and such, right? And it's one of the things that this document leaves open to interpretation at this point in time, in terms of what I'll put in quotes, the absoluteness of academic freedom, and whether it's something that can be balanced off, right? And let's be clear, I think universities may benefit from it being somewhat ambiguous, because for benefit in so much as fear of pushback from not defending it sufficiently strongly, mm-hmm. possible mm-hmm. reputational damage, and likewise fear of being seen to forcefully defend it.
Yeah. We're getting it's about 2:15. Are there more questions, Ange, that we could address?
Yeah, the next one is from George, and George asks, if you were providing advice to a union, what would you recommend they try to negotiate in their collective agreements to ensure that workers have the basic right to engage in political discourse outside their workplace without being sanctioned by their employer unless their discourse violates the law?
Yeah, George, thanks for that question. It's so, I think, essential. And this is the area we're starting to expand on and think about. But I have one thought, and then I will hand over to Danielle, who I know has thought more about this, or just as much as I have, is that there needs to be a frank conversation amongst unions and their membership about but this shrinking of space and that employers are monitoring them outside of the workplace. And there has to be legal language in the collective agreement that recognizes this is happening and outlines what rights that employees have outside of the workplace. I think that becomes essential. There is some minute case law where like employers have tried to discipline workers for like tweeting at work. So like they look at the time and they see, oh, you were actually on the job site when you're doing that. To me, that's an issue that we should be critical of, but at the same time, where it becomes, I think, more powerful and more important for our purposes is that, tying it into that you're at home, you're not on the clock, and you're doing something that the employer catches wind of and then wants to address at the workplace. And I think language and collective agreements that gave some sort of disconnect, I mean, whether we called it that or not, is, I think, irrelevant. What it means is that once they're off the job site, and if they're not tying themselves to the employment, there has to be a way to grieve it where it's recognized that the union has negotiated this and the employer is in violation of the agreement. So if you're asking for language, I would really need to sit down and think about it, but there has to be some form of protection in the agreement that deals with freedom of expression outside of work. And without that, I think unions are always going to be at a disadvantage.
So there's a couple of things I would say in terms of, one is sort of establishing that sort of line of where, between academic freedom and freedom of expression. But to come back to this point in terms of language and thinking about collective agreements and such, I think there's a real possibility here, and hopefully not being too idealistic, but for solidarity, inter-union solidarity here. Because one of the things that's striking is if we look at the collective agreements of our faculty associations and faculty unions across this country, is the differences, the extreme differences in how academic freedom is defined in the varying collective agreements. Some have much stronger definitions, much clearer definitions than others. And perhaps one of the starting points for this to get to your question, I think, is one of, let's begin by having, getting some of the unions together and let's have an analysis. Just look at that sort of clause. Look at compare the clauses across collective agreements. And then see from there, in terms of, what are the more ideal definitions within those collective agreements, and can those be brought forward within more collective agreements across the country?
And outside of academe, if you're a healthcare union right now and aren't thinking about this, then I think that you're doing a disservice in the sense that, where would the public be right now without doctors speaking out about, government policy right now? And I think there's a sense, an inter-solidarity amongst hospital workers and doctors in particular, that they have some freedom to do this because it's serving the public good. But it wouldn't take a huge imagination to see a doctor being disciplined for speaking out against government policy. We're seeing it a lot in my home province of Saskatchewan. The doctors have been, I think, quite vocal, and government has been held accountable in that way. If we were somehow not going to think about that there could be repercussions down the line for some of these more vocal doctors or nurses or long-term care aides, the SCIU deals with those workers, SUN deals with nurses, so that's in Saskatchewan. But without thinking long-term about how much the public relies on those professionals, not just for the work that they do, but for their expertise and speaking out when you have, I don't know what the percentage of long-term care deaths were to COVID in the early stages in the first and second waves, but without those workers speaking out, we wouldn't have the information necessary to hold decision makers to account. Those workers, so it's not just in academics, it's in all forms of work. And even in the private sector that's dealing with, food handling or whatever, there has to be protections beyond the whistleblower notion, because whistleblower notions are a whole different category that, that we have deliberately not touched because we're interested in not just someone blowing the whistle, but workers actually being able to speak to the expertise that they have as workers. And I think that's so vital to think about. And right now, I agree with everything you've said, Dan. Now is the moment.
Yeah. Well said. That was a good rant.
No, thanks. Apologies if I am ranting. It's not thanks for the question, George. That was great. And is there any more?
The next question is from John. Presumably, freedom of expression does not protect an employee whose social media posts demonstrate an unfitness to do their job. For example, a professor of biology who goes through a religious conversion and starts claiming on social media that creationism explains how humans came to be on Earth, or a medical doctor who does interviews claiming that the pandemic is a fraud and should be ignored. But beyond that, should not the only limit be speech that is illegal? Example, advocating violence, making fraudulent claims, or defaming someone.
Go ahead, Dan.
I was just saying the last part in terms of defamation is one of the key ones. In terms of, you'll see in almost every case that we look at, it's one of the first things the employers claim, right? Defamation. Defamation, insubordination, and violation of the duty of loyalty. And so a number of these cases are about whether or not the comments that have been posted online are in fact defamatory. And then in those cases where they're deemed not to be defamatory, but nonetheless damaging to the reputation of the employer, well then alternative modes of discipline are looked for to be more just. So defamation is absolutely there. That's where much of this debate is around in this regard. Now, the aspect in terms of the biology professor who has a religious conversion, again, that would be interesting in terms of where these comments are being made that she or he is posting after post-conversion. Because there's an argument to be made that would nonetheless constitute academic freedom.
Mm.
Right? So I would not want to be the arbitrator on that one. Right? And I'm sorry, I forgot the other example. Andrew, what was the?
Besides defamation?
Yeah, there was defamation. There was the example of the biology professor, and I thought there was another example that.
Oh, a medical doctor who does interviews
right, yeah.
claiming that the pandemic is a fraud. Yeah,
Which has happened.
We have had that. We've had that right here. So that has, and the issue there, of course, is an academic freedom, but it has to do with their respective regulatory bodies, right? The College of Doctors and Physicians and such. So we had a case not too long ago, in the spring, in fact, with a doctor in Mississauga who found themselves in that situation for Twitter posts that were advocating against vaccination. And when brought before the board, the claim that they were saying, no, this is my private life. This is not. And in this case, say, well, have a look at your Twitter bio. Your posts are benefiting from your professional affiliation, and so it was sanctioned.
I agree with the point of the question, right? That why not have the threshold to be harm or violence, which no one would advocate for, not legitimate speech. The Supreme Court's made that clear. Except it gets kind of murky, right? So let me give you an example from a case, and apologies that I don't remember the name of the case. It's just we've gone through so many of them, but it dealt with a worker in a postal office. The union was Cup W. And that worker was having an ongoing conflict with a couple of the managers at the location. She'd never had any disciplinary issues. And one night she had too much to drink and tweeted or Facebook post, I think it was Facebook, saying that I have a voodoo doll here made of one of the managers. And if I wasn't so drunk, I'd go in the car and I'd drive over it. And now, listen, is that a threat of violence? You could interpret it to be that. Or you could interpret it as an employee who just lost their cool and was just venting into the nethosphere. And let's have a debate about that. Let's look at the evidence and see what's going on. She was ultimately disciplined and I think fired for those comments. So, I guess my long-winded answer to that question is that even the threshold you're advocating for, which is an ideal type that I support, it's not clear. In that case, did that employee cross that threshold? I'm not convinced by the case, but some were. Obviously, the arbitrator was. So even that line is difficult to navigate because of these cases are just not what we like. They're just different than we expected to see, and it's not exactly clear. So we need to think about that as well.
I mean, that's been the other eye-opening thing in looking at these cases, doing this deep dive, is that they are multiple shades of gray and many other colors.
Yeah.
It's just clear as mud in many cases.
That's in fact the name of our book. It's not, I'm kidding. That's unwritten yet. We're about 5 minutes in, and I know Jim wanted to make a few closing remarks. So I thought, is there a couple more questions we could quickly address, or how are we doing for that, Ange?
No, I think it's okay to go to the closing remarks now at this point.
Okay, well, can I just quickly say thank you to the audience and for the excellent questions and for Dan's expertise. I really enjoyed this conversation, and it was made richer by your participation. So thank you for that.
Yeah, thank you to the audience. Thank you to you, Charles, and thank you to Jim, and thank you to Ryerson for giving us this opportunity to speak about our work.
Yeah,
very much appreciated.
And to the center, and Ange for your help as well.
Sorry, and the center. Yes. Yeah.
Well, I want to thank the two of you for a very lively, engaging, and informative discussion of a difficult issue that I think is going to become more and more central for all of us. I want to thank the audience as well for joining us today. A video of today's conversation will be posted on our website likely tomorrow afternoon. So if you have any friends, colleagues, people in your network who you think might enjoy this, please let them know. Our website address is cfe.ryerson.ca. Our next event is a week Wednesday. That's November 16th at 4 p.m. Eastern Time. And it's titled Black Stand-Up Comedy as Cultural Critique. I mean, as you may know, Richard Pryor, that great actor Richard Pryor, definitively ripped off the mask of African-American humor in front of white audiences, making it difficult for them to remain passive and uncritical and forcing them to confront the continuing legacy of racial oppression. And Dave Chappelle has continued that tradition, and most recently in his highly controversial Netflix special called The Closer. In next week's event, Terrence Tucker, who's chair of the English department at the University of Memphis, and author of a really interesting book I strongly recommend entitled Furiously Funny, Comic Rage from Ralph Ellison to Chris Rock. We'll be in conversation with Vershawn Young, who is a professor of Black Studies, Communications Arts, and English at the University of Waterloo. This should be trying to unpack what are the limits of comedy, what are the limits of freedom of expression in relation to comedy and social commentary. So for more information about this event or any of the other events in our series that are upcoming, and there's a number that are upcoming, as well as videos of past events that may interest you and you may have missed, please go to our website, cfe.ryerson.ca. Thank you very much for attending today, and I hope to see you at another event in future. Bye-bye.